your life. So, let
Yes. Good evening to all of you. We now deal with section 46 and 45. Yesterday I dealt with. I said if a particular property is purchased in the joint names of A, B, and C, and the respective contribution towards the purchase is not correctly mentioned, or it is not found in the document, all of them are equally entitled to the property. That is one third, one third, one third. That is what we went through yesterday. Today we go through section 46. All these sections except 52, 51, 53, 53A are important, but these are all academic sections which I'll go through in the normal course. And section 46 deals with transfer for consideration by persons having distinct interests. Where immovable property is transferred for consideration by persons having distinct interests, the transferees are entitled equally when it is equal.
So, bit low.
Yes, sir. Here, where immovable property is transferred for consideration by persons having distinct interests, the transferees are entitled equally when it is equal. Where unequal, proportionate value of the respective shares. Here it is said, suppose let us say if immovable property is transferred by persons having distinct interests. Here, distinct interest means one is having half, one is having one fourth, one is having one fourth, or all of them are having equal shares. Let us say, then in that case, the transferee gets the property as per the distinct interest. That is half. That is one fourth. That is actually according to the shares of of A, B, and C. But if they are unequal, the proportionate value. That is the question. Proportionate value means what has been contributed by the transferors as far as the property is concerned. According to that proportion, the property will vest with the transferee. This is what section 46 deals with. Here, the illustration is A is entitled to a life interest in X property, and B and C to the reversion, and the property is sold for 1,000 rupees. A's interest is valid at 600, reversion is valid at 400. Then, in this case, suppose the share of the owner is 600 rupees, value is 600 rupees out of the sale consideration, and the reversion, that is the subsequent people who are also entitled, they get 400. Of course, this is not much of importance, but from academic point of view, we have to discuss this particular section. Then we go to section 47, which deals with transfer by co-owners of common property, where co-owners transfer a share without specifying the transfer to take effect on particular share or shares of the transferee. The transfer takes effect equally where the shares are equal, and if it is unequal, proportional to the extent of such share. Here it is said, suppose let us say the value of A share is 8 NS, and the value of B and C share is 4 NS, 4 NS. It is 2 NS, 2 NS. Then in that case, as far as the transfer is concerned, the transferee, the interest of A is 6 is let us say half. Then the interest of B is 1/4. The interest of C is 1/4. So it goes in that particular proportion. Not much of that is as far as co-owners are concerned. But the next maxim is very important. That is section 47. It is based on the maxim. It is also called the doctrine of priorities. It is qui prior et tempore, potior et jure. One who is prior in time prevails. Here, this is where the person purports to create by transfer at different times rights in this rights over the same property, and such rights cannot at all that is cannot at all to be exercised or to full extent. Then created rights shall be at the advance of binding on the earlier transferee be subject to the rights earlier created. Here, one who is prior in time normally prevails in law. Suppose a property is transferred at different times, rights over the same property, and such rights at all times to be expressed or their full extent, each later created right shall, in the absence of contract, bind the earlier transferee subject to the rights earlier created. Suppose, let us say, a property is transferred at different times to the extent of half, 1/4, 1/4. Then, in that case, to the extent of half, the prior purchaser gets the rights, and as far as the subsequent purchases are concerned, they get the rights according to the proportionate share which is invested by them. This is not much. This doctrine of priorities is now abolished. You don't have this doctrine of priorities now, but still it is there. Suppose, let us say, a plot is transferred to by a society to an individual, and later on the same property is transferred to another person. Then, in one of the cases uh, discussed in discussed in 1998, 2 ALT 266, there they say, as far as the bylaws of the society is concerned, it is not a law. And the earlier purchaser who has purchased the property and the subsequent purchaser, when their rights are to be adjudicated, the prior person has got preference. So the question is, the society was not entitled to sell the same property to two persons. That is, one who is prior in time normally prevails. Then we go to section 49. 49 deals with transferor's rights under the policy. Suppose, let us say, the property is insured with the insurance company, and let us say it is destroyed. Then in that case, compensation is paid by the insurance company, and for what purpose? To reinstate the property in the same position. Suppose the transferee purchases the property and compensation is granted later, the transferor has utilized that money for the purpose of reconstructing the property which has got destroyed. This is what section 49 deals with. Then we go to section 50. Section 50 deals with uh, section 50, rents paid to holder under a defective title. Suppose, let us say, A and B are there, and B is the tenant and A is the landlord. A's title is defective, but B continues to pay the rent to to B, and A pays the rent to B. Then in that case, suppose the property is transferred, the tenant cannot be called upon to pay the rents again, because though he has paid the rents to the defective person with a defective title, it is for the person with a defective title and the new purchaser to adjust their rights, intercede between themselves. But the tenant who has paid the rents bona fide to a person with defective title will not be called upon to pay the rents again. That is what section 50 says. Then 51 deals with what is called section 51 deals with improvements by bona fide holders under defective title. Suppose, let us say, a person to whom a property is transferred makes improvements over the property, or let us say is a tenant, and the tenant makes improvements over the property, and subsequently the property is sold to a third person, and the third person initiates eviction proceedings against the erstwhile tenant. Then in that case, whatever improvements are made by the tenant bona fide in good faith, he is entitled to be compensated the value of the improvements which is made in respect of the property. This is what section 51 deals with. The next section is very, very important, sir. That is called lis pendens. Lis pendens is pendenti liti. No person to the suit, be it the plaintiff or the defendant, can alienate the property, charge the property, encumber the property, or create rival claims in respect of the property without the permission of the court. It is subject to the decision of the court, and when the litigation is pending before the court, no person, including the plaintiff or the defendant, can alienate or sell, encumber the property. And if it does so, it is subject to the result of the suit. Here, in one of the cases, it was said, that is a case reported in 2011 4 ALT 2011 4 ALT page 128 division bench. The division bench in this case said is, so here suppose a matter is suppose a suit is decreed, matter is pending in appeal, but the defendant alienates the property to a third person. Then in that case, though the third person purchases the property, it's subject to the result of the suit because he has purchased it during the pendency of a litigation. And you must also remember, appeal is supposed to be a continuation of the suit, and the suit does not end with the lower court. It continues in appeal, and appeal is supposed to be a continuation. And during the pendency of the appeal, suppose the defendant alienates the property and a third party comes into possession by virtue of that alienation, then in that particular case, he takes it subject to the result of the suit. That is why it is said no person, including the plaintiff or the defendant, can alienate, encumber, or charge the property in any manner whatsoever during the pendency of the suit without the permission of the court. Are you able to understand, please? No person, including the plaintiff or the defendant, can alienate, encumber, charge, or create rival claims over the property during the pendency of a suit without the consent of the court. And even if any person purchases the property, he takes it subject to the result of the suit. Here, section 53 deals with what is called fraudulent transfers. What do you mean by fraudulent transfers? Suppose, let us say, a suit is already filed by A against B. Then let us say B, in order to avoid the property being attached and sold in execution, ultimately, when the decree is passed, he transfers it to a third person or creates a fictitious interest. Then in that case, it is called a fraudulent transfer. And even if any transfer is made in order to delay or defeat the claims of a creditor who has already initiated the suit, it is called a fraudulent transfer. Then
is everything is audible?
Find out.
Is everything is audible? Please mention in the chat box. All right.
Yes. So fraudulent transfer means any transfer that is made by a debtor in order to delay or defeat the claims of the creditor to proceed against the property which is owned and possessed by the debtor. Such a transfer is supposed to be a fraudulent transfer. Again, I repeat, sir, any transfer made with an intention to defeat or delay the claims of the creditor to a third person is void and it is not relevant and it is not enforceable. So that's for what, with what intention the property has been transferred, sir? In order to defraud the creditors, in order to deceive the creditors, or in order to put the creditors into loss. And if it is done during the pendency of a suit or even prior to the suit with the intention of delaying or defeating the claims of the creditors, such a transfer is supposed to be a fraudulent transfer and it can be set aside on the ground that it is actuated with fraud. The here it is said that suppose, let us say, a person is almost sinking and let us say he is not in a position to pay the creditor, then he tries to alienate his property belonging to him. Then in that case, with what intention? To delay and defeat the claims of the creditor. If it is done, then the creditors can initiate action either in the insolvency court or in the civil court and can also ask for what is called attachment before judgment to prevent such transfer being effected. And sometimes in one of the cases, 2004 5 ALT 31.3. Again, I repeat, 2004 bracket 5 ALT 31.3 bracket division short notes in DN. DN means short notes. Here, appellant had filed the suit for recovery of loan. That is, the suit was decreed. A counterclaim was also filed by the opposite side. The counterclaim was dismissed and the suit was decreed. Then subsequently, what happened was, before the decree was passed, 5 days before the decree, the defendant alienated the property, executed a gift deed in favor of his brother-in-law. A question arose whether it's a fraudulent transfer. The courts held that it is a fraudulent transfer which is made in order to delay and defeat the claims of the creditor. And it is also said the creditor or creditors can initiate action against the debtor who has played such a fraud. And this is a judgment rendered in 2004. Again, I repeat, sir, 2004, please write down, 2004 bracket 5 ALT 2004 bracket 5 ALT 31.3 bracket DN. That is on notes on recent cases. Then we go to the most important doctrine in the Transfer of Property Act in general transfers. That is what is called part performance. Here in England, there is an enactment called Statute cannot be made an instrument of fraud. Statute cannot be made an instrument of fraud. Again, I repeat, statute cannot be made an instrument of fraud. All of you by this time know that every transfer relating to immobile property has to be reduced to writing on a properly stamped paper and duly registered. But sometimes what happens is the document, no doubt, it is reduced to writing, but it is not registered. But the opposite side, who expects that particular property has been put into possession of the property, acts on the representation made by the vendor or acts on the representation made by the title holder, makes improvements over the property and treats the property as his own, and is ready and willing to perform his part of the contract by paying the balance of the sale consideration, if any, and also get the document executed and registered in his favor, and he has been put into possession of the property in part performance of the contract subject to the execution of a pakka registered sale deed, his possession cannot be disturbed. Though it may be not registered, but still if the intending purchaser is able to show to the court, sir, I have been put into possession. I have been put into possession under the impression that I become the owner of the property. I've improved upon the property. I've treated the property as my own. I am ready and willing to perform my part of the obligations. And the question is, in part performs the contract, I am in possession of the property. Then in that case, court comes to the rescue of the person who has been put into possession. This is what is called part performance. Statute cannot be made an instrument of fraud is, though it is not registered, though it is not in a proper form, still law comes to the rescue of a person who has been put into possession, does some act relating to the particular property, changes the nature of the land, or let us say he levels the land, or he tries to raise crops over the property, and is in possession of the property, in part performs of the contract, his possession cannot be disturbed. Here, a distinction has to be made, sir. As far as England is concerned, they recognize what is called equitable title. But in India, we don't recognize equitable title. Equitable title or equitable proprietorship. But here they say we follow the Vensorian principle by saying, suppose, let us say, the landlord files a case for eviction, you go from the back door, and royally, after the sale deed is executed in your favor, you come back into the property as the owner of the property. But part performance is an exception to this rule, whereby it is said, suppose you are in performance of the contract, you have been put into possession of the property under the impression that the sale deed will be executed in due course, and that you change the nature of the land, make improvements of the land, thinking that that land belongs to you, you can always plead part performance as a defense to a suit for eviction or suit for any other thing. So here it is said part performance is a shield as far as a person who has been put into possession. So part performance to apply, the land which is transferred to you, you must do something connecting to that land. That is, you must make improvements to the property. You must take possession of the property. You must raise crops over the property. You must show your acts of possession over the property. You must show your acts, which means that already you have been put into possession under the impression that you are the owner of the property and you are the possessor of the property. And though it is not registered, later on it may be registered. Suppose you are able to show you are ready and willing to pay the balance of the sale consideration and get the property executed and registered in your favor, there is an exception to the rule. Statute cannot be made an instrument of fraud. That is the doctrine of part performance. Yeah. But later on, the cases stated that there must be a written agreement to claim part performance. The document should be in writing. It may be in the form of an agreement of sale, it may be in any other form. But a oral agreement is very, very difficult to prove, and part performance perhaps may not apply as far as a oral agreement is concerned. So the essential ingredient is that part performance to be claimed, a person should have a written document in the form of an agreement of sale. He can definitely plead part performs in the contract, saying that he has been put into possession of the property, he has made improvements over the property, he has got a written document whereby the seller has agreed to sell the property. He is ready and willing to perform his obligations. He has changed the nature of the land by making improvements over the property. He has raised crops over the property. Then, in that case, his possession can be protected. This is what the first part of the Transfer of Property Act deals with. Then we go to the second part, sir, which is the most difficult part to understand. We will go at a very, very slow pace. But the purpose of the actually, suppose you are aware of the general of the law of contracts, there are two parts in that. That is general principles, section 1 to 75, and from section 76 to end. That is 217 or 220 of the Contracts Act deals with specific contracts. General contracts, general principles, specific contracts is you have got what is called indemnity guarantee, bailment, agency. But here, in the same way, the Transfer of Property Act, you have also got general transfers, which you have already dealt with. And now we go to the specific transfers, which is from section 54 to 137. The chapters which are contained in the specific transfers are sales. You can note down, please. Sales from section 54 to 57. Sales, section 54 to 57. Mortgages, section 58 to 105, 104. Then leases, 105 to 116. Then exchange, 118 to 121. Gifts, 122 to 128. And actionable claims, 130 to 136. Again, I repeat, sales, section 54 to 57. Sales, 54 to 57. Mortgages, 58 to 104. Leases, 105 to 116. Then my exchange, 118 to 121. Gifts, 122 to 128. And actionable claims, 130 to 136. Again, I repeat, sales are from section 54 to 57. Mortgages are from 58 to 104. Leases are from 105 to 116. And exchange is from 118 to 121. Gifts are from 122 to 128. And actionable claims are from 130 to 136. So this is the entire gamut of the specific transfers. We will discuss a longer topic before we come to mortgages. That is the law of leases. Law of leases is dealt with by from sections 105 to 116 of the Transfer of Property Act. To understand leases better, I'll deal with the Contracts Act. In Contracts Act, I think you must, in specific contracts, you've got a topic called bailment. Bailment, where possession, please remember, I emphasize the word, where possession of movable property is delivered by a person called the bailor to a person called the bailee, where possession of movable property, please understand underline the word movable property, where possession of movable property is delivered by a person called the bailor to the bailee on the for a specified duration of time on the consideration of payment of rent, payment of higher charges. The person who hands over possession of the movable property is called the bailor, and the person to whom the movable property is handed over is called the bailee, and the transaction is called a bailment. And the element what is transferred in a law of bailment is possession of movable property is delivered by whom, sir? By the bailor to whom? To the bailee. For what period? For a specified duration of time. And every contract has to be supported by consideration. That is why, and subject to payment of higher charges and subject to a super added condition that as soon as the purpose is accomplished, the goods will have to be returned back subject to reasonable wear and tear. That is how bailment is defined. But here, you must remember in bailment, What is transferred? Possession is transferred. Then what is transferred? Movable property is transferred. Who transfers it? Bailor transfers it. To whom it is transferred? It is transferred to the bailey. And for what time? For a specified duration of time. Then what is the consideration? Bailor parts with possession of the movable property, and the bailey is supposed to pay the higher charges. And also subject to what? Subject to, after the purpose is accomplished, the goods will have to be returned back. A classic example that can be given is, suppose there is a marriage function in your house. You order for crockery, you order for tents, then you order for spoons, you order for glasses, and you order for even for what is called distilled water. All these things belong to the bailor, but you take it for 2 days. And after the 2 days are over, you pay the higher charges for each article, possession of which is delivered to you. And then once the function is over, you have to deliver back all the articles which you have taken. You come into temporary possession of the property for the specified duration of time, but you have to pay the higher charges. And also subject to return of the goods which has been handed over to you. That's the law of bailment, isn't it, sir? Now, with the same background in view, we define what is a lease. Please remember, don't think that I'm avoiding the other topics. The leases, I can finish it. Mortgages is a lengthy chapter. We'll take it in the end because it requires more explanation. Here, as far as the lease is concerned, lease is defined as where there's a delivery, or where there's a transfer of possession by one person called the lessor to a person called the lessee. Where there's delivery of possession by a person called the lessor to a person called the lessee for a specified duration of time, on the superadded condition is that the lessee has to pay the rents in respect of the property every month and for a fixed duration of time, and after the accomplishment of that period, the lessee has to return back the de-delivered possession back to the lessor. So what is delivered in a lease, sir? Possession is delivered. For what purpose? For rental or for commercial purpose. Who delivers it? It is delivered by the lessor. To whom it is delivered? It is delivered to the lessee. What is the consideration? The lessor parts with the possession of the property, immovable property. Please underline the word immovable property. Possession of immovable property for a specified duration of time, subject to payment of rents, subject to payment of rents, and also de-deliver possession after the expiration of the period of the lease. This is called a lease. Are you able to understand, please? Again, I repeat, where there's a transfer of, where there's a delivery of possession by one person called the lessor to another person called the lessee for a fixed duration of time for a residential or commercial purpose, whatever it may be, and subject to payment of rents, share of crops, annuities, or profits arising out of the business, and subject to a superadded condition is, once the purpose is accomplished or the period expires, possession of the property has to be re-delivered back to the lessor. The person who is the landlord is normally called the lessor. The person who is the tenant is called the lessee. And the amount which you pay towards rent is called the consideration. And the possession that is given to you is a consideration for letting it out to you on a fixed rent, whatever it may be. And it is given for a fixed duration of time, and on the superadded condition that when the period expires, you have to re-deliver the possession back to the landlord or back to the lessor. This is what 105 defines a lease as. Or in the colloquial language, you can call it a tenancy, rental agreement. But the difference between a rental agreement and a rent note, and lease is, a rental agreement is a unilateral document. Unilateral document means it is executed by the tenant in favor of the landlord. Rent note. What do you mean by rent note? This is followed mostly in the agency area in Vizag, Srikakulam, and other areas. Rent note means mostly printed receipt books are available in the market, isn't it, sir? In that, if you see the backside, T&C are there. That is the terms and conditions are incorporated there. There, every month rent is paid, and the conditions of tenancy is mentioned in the reverse. That is what is called a rent note. And as far as lease deed is concerned, lease deed is supposed to be a bilateral document executed by and between the lessor and the lessee. Why, sir? It is executed by both of them because there are some obligations which are attached to the lessor. There are some obligations that are attached to the lessee, and there are certain covenants which the lessor has to follow. There are certain stipulations which the lessee has to follow, and also there is a stipulation regarding the rent, and there is a stipulation regarding the payment of rent when it has to be paid. Then there is a stipulation when the tenancy, when the lease commences, when it ends, and then there is a stipulation also that the lease is given for 3 years, let us say. Then it is said after the expiry of the third year, the rent shall be enhanced by 10% of the existing rent, 10% of the existing rent. And apart from that, as far as commercial premises are concerned, sir, in Hyderabad, there's a practice that the tenant has to pay the municipal taxes from time to time. And apart from the rent, the lessee has to pay the municipal taxes, electricity charges, and if water supply is also given, water charges also has to be paid. And if any maintenance is charged by the society in which the commercial premises is located, the tenant has to pay the maintenance charges. All these terms and conditions are incorporated in the lease deed. And since some obligations are on the part of the lessor and some obligations are on the part of the lessee, their respective responsibilities are reduced to writing and it is mentioned separately in the same document. And that is the reason why both the lessor and the lessee sign and its witness attested by two witnesses. Then, sir, as far as agricultural leases are concerned, they are called in Telangana, we call it as Kabuliyat, Kabuliyat, Kabul Nama or Kabuliyat Nama. That means a rental agreement as far as agricultural land is concerned. In the agency area, it is called the Pauthi, Pauthi. Pauthi means it is the agreement which is executed by the tenant, by the kauldar, the person who cultivates the land, and to the owner of the property. That is called a Pauthi in the agency area. In the Telangana area, it is called the Kabuliyatnama. Kabuliyatnama means an agreement, rental agreement, executed by the tenant in favor of the landlord. Here a distinction has to be made, sir. The terms of tenancy will be fixed. Suppose the tenancy commences on 1st and ends on 31st. Please bear one thing in mind, sir. 31st is not a full day. Till 31st, 12 noon, 12 midnight, it is 31st. From 12:01, it is 1st, isn't it? Then as far as then here, when we say from 1st to 31st, it means the next tenancy month commences on 1st of next month. And there are two types of leases, sir. One is called periodic lease. Periodic lease as far as residential and non-residential, that is commercial properties are concerned, it is supposed to be month to month. As far as residential and non-residential properties are concerned, it is supposed to be month to month. As far as residential and non-residential buildings are concerned, it is supposed to be month to month. As far as agricultural, manufacturing, industrial, or educational leases are concerned, it is supposed to be year to year. As far as agricultural, manufacturing, or industrial, or let us say educational institutions, it is supposed to be year to year. So, what is the distinction, sir? Suppose, let us say, the tenancy commences on 1st. When does it end? When does that month end? It ends on 31st. When does the next month start? It starts on 1st. Then again, in February is a controversial month, sir. It ends on 28th. And again, the next month starts from 1st. And sometimes, Adhika Masam also is there, 13 months. Then you've got different types of calendars. We follow the Gregorian calendar, that is the English calendar. English calendar is always, it is from 1st to the end of the month. But Telugu calendar, which is normally followed by Vaishyas and some of the business communities, it is from Amavasya to Amavasya. Please remember, Amavasya does not come in the same date the next month. This month, especially the Amavasya was supposed to be on 4th. Next month it will be on 3rd. After that it will be on 2nd. After that it will be on 1st. Like that it comes. So here, as far as the Vaishyas are all concerned who follow Telugu calendar, it is supposed to be Amavasya to Amavasya. I don't want to go into the numerals, please. I am not aware of that Pashyami, Gushyami and all what they say in Telugu. Here, but English is, it is supposed to be from 1st to the end of the month. And next month, the next tenancy month starts. Then the question is, as far as residential and non-residential premises are concerned, it is supposed to be month to month. And normally, I think this question was asked very, very often by most of the candidates who are now taking this Dharma legal classes. Here, sir, the question is, here, the question is, here, suppose let us say 11 months. What is the significance of taking a lease deed for 11 months? Previously, the position was that if you take it for 11 months, it doesn't require registration. But you have to pay the stamp duty. Stamp duty has to be necessarily paid. That is, normally the stamp duty for a lease deed or a rental agreement is 3% of the annual rent. That is a stamp duty. But most of them take it on 10 rupees stamp paper, 50 rupees stamp paper, or 100 rupees stamp paper. And even big institutions, big companies also take it on 100 rupees stamp paper. Please bear one thing in mind. So long as there is no dispute between the landlord and the tenant, or the lessor and the lessee, there is no problem. But once it comes to the court, the proper duty has to be paid. The deficit duty, which is liable to be charged for a lease deed or a rental agreement, is the 3% for 3 years, and above 3 years it is 5%. If you don't pay the proper stamp duty, the deficit is collected from you plus 10% of the actual duty is levied towards penalty. Unless you pay the duty and penalty, the question is the document cannot be relied upon. Though for a collateral purpose it can be gone into, but for the main purpose you cannot rely on that document. But unfortunately, the companies, what is happening is the officials are not advising the management properly. Why? Because they say 100 rupees stamp paper chalta. Because chalta, it's all right. So long as your tenant is no problem for you, there's no problem. But once the tenant creates problems for you, please remember it will cost you a fortune as far as paying the duty and penalty is concerned. Here itself, I want to mention that sections, all properties of the value of 100 and above has to be in writing and has to be duly registered. This is fortified by the amendment to the Registration Act 17(1)(b) has been introduced, whereby they say that every transfer of immovable property, either by lease, either by sale, either by mortgage, or any other means, has to be in writing and has to be duly registered. It is absolutely mandatory now. So the question of taking it for 11 months, not getting it registered, no longer works. Even if you give it for 1 month, the entire stamp duty has to be paid and the document has to be registered. So 17(1)(b) you have to make note of, saying that please, if you are the landlord, take it on a properly stamped paper and get it registered also. If you don't get it registered, please remember, don't be under the impression that since it's only for 11 months, it doesn't require registration. But under 17(1)(b), every transaction relating to immovable property, whether by release, whether by sale, whether by mortgage, whether by gift, whether by lease, or which reserves an annual rent, it has to be reduced to writing and it has to be duly registered. So that is the statutory embargo imposed by 17(1)(b) of the Registration Act, which came into effect from 1/7/2001. Then the question is, there are two types of leases, sir. One is called a statutory lease and another is called a contractual lease. Statutory lease means all leases or all tenancies which come within the purview of the Rent Control Act of the respective states concerned. Here in Andhra Pradesh or Telangana, you had an act called AP Buildings Lease Rent Eviction Control Act of 1960, and this has been adapted by the present state of Telangana. where it is said, suppose you want to get rid of a tenant, you have to follow the statutory provisions. Here, the statutory provisions are under section 10, the tenant must have committed default in payment of rent, he must have sublet the property, or the property in occupation of the tenant is required for your residential use, for your self-occupation, or the property in occupation of the tenant is required by you for establishing a business or starting a business, or the tenant has secured alternative accommodation, or he has ceased to occupy the property for a continuous period of 4 months, or the tenant has committed acts of nuisance, or the tenant has committed acts of waste, or so many grounds are there as far as section 10 is concerned. And the conditions which have to apply is, if it's a municipal corporation area, the rent should not be more than 3,500, and it should not, the age of building is less than 15 years. It automatically comes under the Rent Control Act. And next one is, you've got other corporations, are the municipal councils are there. There the rent fixed is, it should not exceed 2,000. If it's less than 2,000, the Rent Control Act applies. Then one more thing you must remember is, suppose you are asking for self-occupation of the property in occupation of the tenant. Then the tenant belongs to the essential service. He is an employee of the state or the central government, or the undertakings of the state or central government. He cannot be evicted on the ground of self-occupation. There is a protection given to such tenants. But if the landlord also belongs to the essential service, he is also an employee of the state government or the central government or the state government or central government undertakings, then in that case, the landlord's claim will have preference over the tenant's claims. And there is one more ground, sir, additional accommodation also is there in the section 10. It says, suppose your family has grown, you require more rooms for accommodating your family members, you want privacy, then in that case, the portion in your occupation is not sufficient, then you can ask for additional accommodation, saying that the tenant has to vacate and deliver possession to you on the ground of additional accommodation. That is 10(3)(c). There they say the advantage that is caused to the landlord should outweigh the hardship that is caused to the tenant. Then in that case only, additional accommodation can be permitted. There is one more ground also, sir, to say that you have 3 or 4 more buildings, but this building which is occupied by the tenant is required by you for your self-occupation. It is not for the tenant to dictate terms and say, be happy like a Maharaja in your own house. Why do you want the house where I am a tenant? Please remember, so long as the right to property is recognized in this state or in the entire country, the question is, it is not for the tenant to dictate terms. That is a classic judgment of AR 1971 AP. That is of Justice P. Ramchandra Raju. Please remember, the Rent Control Act, the purview of Rent Control Act, the purpose of Rent Control Act was prepared by the ex-Chief Justice of the Andhra Pradesh High Court, Justice Gopal Roy Bote, and he was asked to draft the Rent Control Act, and because he drafted it in such a way, because he had properties at Kachaguda, he was fighting a running battle with the tenants, which went up to the Supreme Court, and for 25 years he could not get possession of the property. And when he was asked to draft the Rent Control Act, he drafted it in such a way that it benefits the tenants. But if you see the preamble of the Rent Control Act, also it says, to prevent unreasonable eviction of tenants from the properties in their occupation, the Rent Control Act is formulated. So the question is, again I say, justice varies according to the foot of the chancellor. In Karnataka and Tamil Nadu, it is very difficult for you to get rid of tenants because most of the judges are tenants in private properties. They are not occupying quarters. So they know the difficulties of tenants. So the question is, and most of the judgments in Karnataka and all are tenant oriented and they are not towards landlord. But here, as far as our High Court is concerned, the erstwhile AP High Court also, here they say they didn't follow that dictum. Here they say, because most of the judges are landlords, they mostly tilt more towards the landlords rather than the tenants. So this type of leases which are created under the rent statute is called statutory lease. Then we got the contractual lease, which the present subject we are dealing with is contractual lease. In labor law, there is a maxim: you cannot keep you cannot keep a person a servant in employment with on whom you have lost confidence. You cannot trust the employee on the landlord, and that is the reason the landlord can terminate the tenant at the employee at any time. But here in contractual lease, what is the contractual lease? There's a contract between the landlord and the tenant, or the lessor and the lessee, that possession of immovable property is delivered by whom? By the lessor to whom? To the lessee. On what consideration? The consideration being the rent paid, and it's for a fixed duration of time. That is 11 months or 12 months or whatever it is. Then, on the condition that once the term comes to an end, the lessee has to vacate and deliver possession back to the landlord or to the lessor. So the redelivery of possession is mentioned. Please remember, you cannot say, I want to stay for a longer time, I don't want to vacate, I don't want to get rid of this. It's purely a contract which comes to an end on the expiration of time. In the Rent Control Act, it is not there. The statute protects you. But here, it's an out and out contract between the lessor and the lessee for a fixed duration of time on payment of rent. And once the time comes to an end, the possession has to be redelivered back to the lessor. So, element of redelivery is provided under the under section 105. Are you able to understand, please? But here, mostly what we do is, as clever advocates, we draft the document in such a way that the tenant is always blocked. Though we give it for 3 years, or let us say 5 years, then we include a clause there, notwithstanding anything contained in the above paragraphs, above stipulations, if the tenant commits a default for 3 consecutive months, he is liable to be evicted without any notice. That means there is a restrictive clause saying that the tenant has to perform all his obligations, and if he defaults in payment of rent, irrespective of the protection given to him under the lease deed, he is liable to be vacated. Then please remember, there is one more clause also which we include, sir. We say in case the lease has to be put an end or to be terminated, 3 months advance notice has to be given on either side. On either side, terminating the lease. Why this 3 months time is given, sir? This 3 months time is given because to enable the lessee to secure alternative accommodation. Then there's one more clause also which is included in the lease deed, sir. This lease is executed for a period of 3 years, and after the expiry of 3 years, it is open to the lessor and the lessee to extend the lease on subject to mutual terms and conditions and subject to enhancement of rent by 10% of the existing rent for every year. So that is normally included, sir. And please remember, again I repeat, every lease of property that is where it exceeds 100 rupees, it has to be in writing and it has to be duly registered. And the question is, if it is below 100, mere delivery of possession is sufficient, but payment of stamp duty is not exempted, though you may not register it. But now under the new law, after the amendment of 17(1)(b), even if it's for 1 month, it has to be registered. And the disastrous consequences of not engrossing it on a proper stamp paper is you have to pay the deficit duty plus 10%, plus 10 times the duty as penalty you have to pay before the document is admitted in evidence. Then coming to agricultural leases, manufacturing leases, industrial leases, or as well as educational institutions leases are concerned, it is supposed to be year to year. Why? Because if you take the case of educational leases, please remember you cannot expect the school to shift immediately. They have to secure alternative accommodation, and the academic year will be disrupted. That is the reason it is said, as far as educational institutions are concerned, 6 months notice has to be given. And as far as agricultural leases are concerned, 6 months notice has to be given. Why? Because suppose the seeds are already sown and the crop is ready for harvest, you cannot disturb the kaldar or cannot disturb the tenant during the harvesting period. That is the reason why 6 months period is normally given. If you take the case of industrial houses and manufacturing houses also, 6 months time is given so that they may be given time to shift their machinery and to secure alternate accommodation. This is as far as leases are concerned, as far as 105 is concerned. Then the question arises, there are two terms, sir. One is called termination and one is called determination. Both appear to be synonymous, but they are not synonymous. Determination means where it is given for a fixed duration of time, where it's for a fixed period of time, and once the period of time comes to an end, the lease gets automatically determined or lease comes to an end. No notice is necessary. But the next day itself, you must file the suit. No notice is necessary in the case when it is when the lease is already determined by the period expiring. But termination means where the tenant remains in possession of the property even after the lease period has come to an end. He can be thrown out or he can be evicted only after issuing a proper notice under the provisions of Section 106. Then please remember the only amendment which has taken place in the TP Act is 106. Section 106 has been amended somewhere in 2018 or 2019, where they say, because we have got different types of tenancies and different types of leases. I told you that most of the people follow the Gregorian calendar, that is the English calendar. There are some people who follow the Telugu calendar, that is Amavasya to Amavasya. There they say, normally the defense which is taken by the tenant is, sir, my tenancy does not commence on 1st. It commences on 10th, or it commences on 15th, or it commences on 14th. And the notice which is given is not according to law. The tenancy is not properly terminated. But by this amendment, it has mostly come as pro-landlord, where they say the wording is, you are hereby called upon, your tenancy is hereby, your lease is hereby terminated by 31st May 2024 or any day which according to you is the last date of your monthly tenancy, and you are called upon to vacate and deliver possession by 1st of next month. But the notice period which has to be given is 15 days notice has to be given. It shall not fall short of even 1 day. If it falls short of 1 day, your notice is defective. And what we do normally is, instead of 15 days, we give them 1.5 months time. Why? The reason being, the tenant may manipulate with the postman and try to not to receive the notice. Then the question of notice is not delivered to him. Unless the notice is delivered to him, it has not come to his knowledge. So for that reason, we give 1.5 months time to send it to terminate to vacate. So the wording which you have to use is, your tenancy is hereby terminated by so and so day, or any date which according to you is the last date of monthly tenancy, and you are hereby called upon to vacate and deliver possession by so and so, that is by 1st of next month, failing which legal action will be taken. Suppose, let us say, the lease deed mentions that at least 3 months notice has to be given. Then you have to follow the lease deed to say you must give 3 months notice in writing and terminate the lease. If you don't give 3 months notice, your notice is defective. Why I'm trying to tell you all these things is, the expenditure which is required for filing a suit under the TP Act is very, very expensive. The court fee which you pay in respect of the suit is you pay it under Section 40 bracket 2, the Court Fees Act. Now, the annual rent plus the premium which you have taken, premium means the advance which you have taken, both have to be added up, and then you have to pay the court fee on that consolidated figure. Then suppose any arrears of rent is due to you, then in the second clause you say arrears of rent from so-and-so to so-and-so, aggregating to rupees so-and-so to so, aggregating to rupees so-and-so. Till what time you can claim the arrears of rent, sir? You can claim the arrears of rent up to the date of expiration of the notice. After that, I'll come to it, what you are entitled. Then the third one is, if the tenant continues to be in possession of the property in spite of having given him the notice to vacate and deliver possession to you, he becomes liable to pay the landlord or the lessor damages and compensation And in the legal language, it is called mean profits, MESNE, not messy profits. It's called mean profits. That means towards damages and compensation to remain in possession even after the lease has expired, the tenant becomes liable to pay mean profits. And mean profits is depending on the prevailing rent in the locality, prevailing rent in respect of the same accommodation, the vantage position, vantage locations which are located nearby. Based on that, the mean profits is fixed. Suppose you are getting a rent of 15,000 rupees. Suppose the tenant vacates, you will be getting 30,000 rupees. That 30,000 rupees will be the mean profits which you claim. And when you file a suit for eviction or possession, you have to file a consolidated suit. You have to file a suit for eviction and possession. Second one is arrears of rent. And third one is proportionate mean profits. Till the date of filing the suit, you have to value the amount and then pay the court fee and cost of the suit. And please remember, in a TP Act suit, you have to also mention the schedule correctly. I think with this, we'll stop. And now the interaction period starts.
Madam, unmute, sir. Any questions for today? Yes, Mr. Vasandrao garu, please go ahead.
Sir, good evening, sir.
Good evening.
Sir, good evening, sir.
Good evening, sir.
Are you, my voice is audible, sir?
Yes, sir.
You're audible, sir.
Kindly proceed.
Sir, A owes some money to B. A wants to file against A for the recovery of money.
Right.
A has only property in the joint family property he has right and interest.
Yes.
He can file the attachment. Can take attachment of the joint family properties of A.
Enhancement?
Attachment of property. ABJ.
ABJ only to the extent of the share which the defendant would have got in respect of the joint family property. Not the entire property, sir. Only to the extent of your B's share in the property.
Yes. He has, for imagine he has a 25% of joint family property.
The joint family property may be having 1/4 share or 1/8 share. Whatever share he has got, you can attach that share and or ask him to furnish security for the suit claim.
We have to make parties on other sharers, co-persons also party.
It is better you make them parties.
Okay, thanks.
Anybody else?
Sir, not 6 of Transfer of Property Act, if eviction suit is initiated, 1 month rent is to be paid as the court fee, sir?
No, sir, not 1 month's rent, sir. 1 year's rent. That is annual rent. Annual rent plus the advance which you have taken.
Oh.
That is under section
So
40, bracket 2.
So it is totally disadvantageous to the landlords, sir?
It is disadvantageous, but one thing you get easy possession in a TP Act suit rather than Rent Control Act.
Okay.
All right.
So this transfer of property is applicable if the rent is more than 3,500, sir?
More than 3,500, sir. Exactly.
Okay. In all the cities, it is the uniform or it is
No, sir. It's
from
different
place
in
to
different
place?
cities. But the bill was there during the previous TRS government. They wanted to enhance the figure to 10,000 rupees. 3,500 rupees, you don't get a single bedroom also.
Correct. Okay, sir.
Thank you. Any more questions for today? Or can we conclude the class? Reversion.
Reversion and reversional.
Reversional means, of course, the element of reversion doesn't lie now. Reversion means vagera. Here and before the Hindu Succession Act, the women's estate was supposed to be a limited estate. She cannot alienate the property, she cannot charge the property, she can enjoy the property only so long as she is alive. But to pay the debts of her husband, she can sell part of the property when it's a legal necessity. But reversioners mostly now are extinct. They are not prevalent today. Reversion means vagera, the other persons. That's called reversion. Are you able to understand, madam? Reversioner means others, apart from the transferee, other persons. Reversion is not available now. Mostly it is gone.
All right, Mr. Sam, please go ahead. Sam?
Sir, yes, sir. So, is the doctrine of part performance is applicable in partition suit, sir?
Doctrine of part performance is not available in partition suit, sir. It only applies in the case of sale transactions. Of course, perhaps in a partition suit, you can claim extra amount if you have made improvements to the property. The other sharers will have to compensate you for the repairs or the improvements which have been made to the property.
Okay, sir.
Yes, Mr. Venkatreddy garu, please go ahead.
నమస్కారం
Yes.
నమస్కారం సార్
చెప్పండి నమస్కారం చెప్పండి
సార్ ఇది ఎవిక్షన్ సూట్ ఓవరాల్ టెనెంట్స్ తోటి 11 months టెనెంట్స్ అని 3,500 అని రెంట్ అని సార్
ఎంత
3,500 సార్
రైట్
రెంట్
రైట్
అయితే ఓవరాల్ టెనెంట్స్ ఎలాంటి డాక్యుమెంటేషన్ టెనెంట్ కింద మనం ఎలాంటి టెనెంట్స్ ఎలాంటి డాక్యుమెంట్ రాసుకోకుండా సూట్ చేయొచ్చునా సార్ 106 కింద నోటీస్ ఇచ్చి
106 కాదు 3,500 రెంట్ ఉంటే రెంట్ కంట్రోల్ యాక్ట్ వస్తుంది.
సార్
Yes, not in the TP Act.
అంటే మనకు ఓవరాల్ టెనెంట్స్ అని చెప్పి మనం చేసుకోవచ్చు సార్
ఓవర్ ఉందని చెప్పొచ్చు కానీ అదర్ సైడ్ విల్ సే రెంట్ ఇస్ 3,500 3,400 only. One it is less. If it's less than 3,500 or 3,500, only rent control act applies, not the TP Act.
ఓకే more than 3,500
TP Act is a contractual lease.
okay
All right, any more questions?
thank you sir
Thank you. Any more questions for today? All right, thank you. We'll see you again.